Okay. So today we are going to discuss about the contract. So what is contract and why it is important in international trade? That is what we are going to discuss in this contract chapter. Okay. So basically, contract is a written document. Contract is a written document and it is bounded by the governing rules or legal system. So the contract means it is a written document, is a written document, and both the parties, in our case we are considered both the parties, for example, exporter and importers both give their consent. Okay, so by and large, it is governed by legal system. So this is what contract is, and it is very essential part of this international business. So first and foremost thing, you need to enter into a contract, and then you can go ahead with this shipment of goods and everything. And this contract is contained, Malawi is going to contain all the aspect of this international trade. So be careful. It also includes from the date of signing this contract till the completion of this contract and receiving the payment. So everything should be there in this contract. So whenever you people are going to sign any contract, be careful. Take maximum time to read it. I think if you think that this is not a proper sentence, just change it with the consultation of other party as well as. Okay, but don't take it lightly and say it's okay, no issues, because this is going to be a written document. So whatever written sentence or whatever it is written in this document is going to be considered in the legal system as a valid point. So be careful. Okay, so obviously in international trade there are two parties involved in this international trade. One is exporter, another is importer. Exporter is residing in, say for example, one country, and the importer is residing in another country. So the major difference in this international trade is that here you need to understand the legal system of both the countries. So as far as domestic trade is concerned, you need to just take care of your own country, that is domestic part. So it is expected that you people are well aware with the domestic trade rules and regulations. But in international trade it is very complex, reason being that jurisdiction of the two countries to which exporter and importer belongs are completely different. Okay, this is first and foremost thing, and that is why you need to take care of this contract, where you need to take care of signing this contract initially. Okay, all the international transactions are conducted. Okay, remember, all the international transactions are conducted according to the terms and conditions negotiated between exporter and importers only. Okay, that means once you sign this document, that means it is expected that you read it, you go through the entire documents, and now you are convinced, and that is why you have signed it. Okay, and this is considered as a legal document, so be careful. So these documents are prepared once importer and exporter agreed on certain conditions. Okay, by negotiating term, exporters secure the deals. Okay, it is clear. Minimize the risk and protect his company in case of possible trade dispute, claims, or legal actions. Why we are entering into a contract? Reason is simple. This entire international trade cycle, the entire international trade cycle is going to be of, say, for example, of 6 months, 7 months. During this 6 months, 7 months, it might possible that one or more party who already involved in this transaction might have certain problem due to so many reasons. We are not discuss what could be the reasons, but due to some reasons they are in a dilemma that whether this is what the situation is now, what to do. So in that case, if you have a written document with you, you can tell them that, sir, as per this documents, you need to do this, I need to do this. Okay, by any way, because we have agreed upon certain terms and conditions. So in that case, when there is a trade dispute or there is a legal time of taking legal actions, at that time such kind of documents will be helpful. So be careful while signing or making this contract deal. Okay, so what are the basic elements that you need to take care? So here we are not going to discuss how to write a contract, but be careful. Whenever you see any contract, be careful. Okay, what you need to see first is a mode of transport and a shipment. Be careful. If it is written, say for example, you are going to send the goods by ocean, then check it whether it is possible or not. Once you sign it, say for example, you have signed it, and now you think that, oh no, I need to send through an air. Okay, so it might possible that there will be a dispute. Okay, because once you use these air freight, the cost air freight is very costlier, heavy costlier than the ocean freight. Okay, but the problem is that if you use the air freight, air transportation, the time involved in this transaction or shipment is very less, but it increases the price. So it might possible that importer will not agree on that. So be careful while selecting the mode of transport, discussion on transportation and shipment. Proper law of a contract should be there. Okay, this is the most important thing. Huh? Be careful while selecting this contract of law. The parties, the contract such exporter or a consigner and importer or a consignee. Be careful whether you are an exporter or a consigner, whether importer or a consignee. Okay, it might possible many a time importer is a different thing and consignee is a different thing. So whenever you prepare the documents, whenever you submit the documents, be careful whom to submit and what kind of documents need to be submitted. Okay, detailed description of the product is required because it might possible that later on the importer will find, oh sir, I have ordered this and you send it to me this. So in that case, you can clearly show, you can clearly put this document in front of them where it is clearly mentioned about the detailed description of the products. Doesn't matter whether it is a 5 page or 20 page. It is not the major concern, but the major concern is give detailed description of the product that you are going to export. Then quality standards. Now during this COVID-19, be careful in quality standards. Ask importer to provide what kind of desirable quality. Ask importer to provide desirable quality standards. We will follow the regulations in terms of quality standard is concerned, but still, if he or she requires extra take care for quality standards, tell them to provide in a contract so we can arrange that. Second thing is passing over property. This is going to be most important. If you are a consignee or an importer, please inform or announce well in advance that how to transfer the title of a goods. Okay. Second thing is passing of a risk as agreed through incoterms between parties. This is you need to discuss well in advance that what kind of incoterms you are going to use, FOB, CIF, D term or E term. Okay. So out of this E, F, C and D term, you need to select any one. Majority of the times it is FOB and CIF, but still you ask the importer about this incoterms and be careful in selecting the incoterms because it is directly affect your pricing. Okay, availability and non-availability of export import license. This is the first step that you need to understand whether it requires any license for the importer, and if he says yes, a license is required for importing any goods from particular industry, then ask him to provide the license or ask him to, sir, please generate the license and show it to me. It doesn't require that you submit the license, but just show it to you. Otherwise, what happened that you ship all the goods and you find that okay, importer requires to have a license, but he did not have. So at that time, it might possible that your goods have been on the port of this destination. So in that case you may face any difficulty, but this is not possible because let me tell you very honestly, this is what the practical word is. Before importing any goods, importer must have an idea how to import. So if a license is required, he may get this. So this is what not the major problem, but ask him that okay sir, any special license is required in your country, just let us know so we can arrange or you can arrange, no issues. Mode of payment term, this is what the most important thing, and ultimately this is what the final fruit that we are working for this international business is. So you need to take care of selecting the payment modes and the terms. Okay, so it is up to you that is whether you wish to get an advance payment, or you are going to use LC, or you are going to use bank collection method, whether you are going to use consignment sales. Okay, so be careful in selecting the methods, and once you decided that okay we are going by bank collection method, then select whether you send or you are going to give them credit. So that term should be there, and the term should be clearly mentioned or clearly indicating that okay you are going to give them 40% 40 days credit period or 60 days credit period. The fourth thing is tax and charges is applicable. So who is going to pay? What is the responsibility? How to pay? Okay. And the first and the last and foremost point, say for example, as a product is concerned, is packing and packaging of a goods. Second thing is labeling as well. So be careful. This is international trade, and packing, packaging, labeling matters a lot in international trade. Okay. So just look at the examples or just study the local rules available in the importer's country. I asked many times about the packing, packaging, and labeling styles prevailing in the importer's country. Take a help of importers and then decide. Okay, this is what the final situation. Many times it happens that once we supply all the goods to, say, for example, any specific country, culture matters a lot in this packing, packaging, and labeling uh, kind of problems as well. Credit period, as already we have discussed in the second point, that is mode of payment. Post sale service and warranties. Be cautious while providing such kind of post sale service and warranties, because it might possible that the interpretation of sales service and warranties would be different from importer and exporter side. Take appropriate marine insurance, and also discuss who will be the liable for taking this marine insurance. And also different countries have different rules in terms of marine insurance is concerned, so be careful. Settlement of dispute, this is not the most important thing. If there will be a dispute between exporter and importer, how to settle this dispute, whether we are going for arbitration or whether we are going for negotiation, or whether we are going say for example arbitration, negotiation, or litigation. So this is what you need to discuss well in advance. Also, you need to mention the price per unit of a goods, total value of the order, marking and labeling. Already we have discussed delivery. Okay, so it directly or indirectly comes under the Incoterm. So clarify those. Jurisdiction in case of dispute, which jurisdiction you are going to use, exporters, importers, or a third party. Quality control and pre-shipment, it is also related with this quality standards. Okay, trade documentation as required in a country. Now this is going to be most important because it is also also required in LC. So ask importer first, tell him to mention all the documents he required in the contract. So from the for day one, you start preparing those documents. You start collecting all the documents. You maintain a file, and once the entire shipment is completed, you just submit all the documents to a bank, to the importer. And the most important thing is force majeure, which is known as act of God. Be careful, because force majeure is having a different rules and regulations. So be careful and mention all the uh, advanced definition of force majeure, because this is ultimately passing a risk from one shoulder to another shoulder. Okay, careful in taking mode of payment, delivery date, credit period, quality issues, port of shipment, post of sorry, it is a port of destination, mode of transit, insurance policy. Be careful, read twice and thrice in these terms and conditions. Okay, whether it requires 5 days doesn't matter, but be careful in this kind of things. Okay, so if it requires more time, no issues, but read once and twice. And if you are having any confusion, take an help of any legal advisor, but be careful. Okay, so this is what the international contract is.